In the United States, the age of consent refers to the minimum age at which an individual is considered legally old enough to consent to sexual activity. This concept is rooted in the belief that young people, especially minors, may not have the maturity or understanding required to make informed decisions regarding sexual relationships. As a result, laws have been established to protect minors from exploitation or abuse by adults. However, the age of consent is not uniform across the country. Instead, it varies from state to state, with each jurisdiction setting its own standards and exceptions. Most commonly, the age of consent in the United States falls between 16 and 18 years old. But there are nuances and specific provisions that can alter how these laws are applied. Let's begin by examining the general framework. In the majority of states, the age of consent is set at 16. This means that individuals who are 16 years old or older are legally permitted to engage in consensual sexual activity with adults or other peers. However, in some states, the age is set higher, at 17 or even 18 years old. For instance, states like California and Florida have established the age of consent at 18, reflecting a more cautious approach toward protecting minors. It's important to note that age of consent laws do not simply draw a line at a particular age. Many states have adopted what are known as close-in-age exemptions, commonly referred to as Romeo and Juliet laws. These provisions recognize that teenagers often engage in romantic relationships with peers close to their own age. Romeo and Juliet laws can protect young people from prosecution for engaging in consensual sexual activity if both participants are minors and the age difference between them falls within a specified range, often 2 to 4 years. For example, in Texas, the age of consent is 17, but a minor as young as 14 may legally consent to sexual activity with someone who is no more than 3 years older. Despite these exemptions, age of consent laws are strict when it comes to adults engaging in sexual activity with minors. Anyone found violating these laws may be charged with statutory rape. Regardless of whether the minor appeared to consent, statutory rape is considered a serious crime in all jurisdictions, and penalties can include imprisonment, fines, and mandatory registration as a sex offender. The purpose of statutory rape laws is to recognize that minors may not fully comprehend the consequences of their actions, and that adults bear a greater responsibility to respect those boundaries. This approach aims to prevent situations in which a minor is manipulated, coerced, or taken advantage of by someone older and potentially more experienced. Let's explore some specific examples to illustrate how age of consent laws differ across the country. In New York, the age of consent is 17. If an adult engages in sexual activity with someone under that age, they may face criminal charges. However, New York also has close-in-age exemptions. Minors aged 16 or younger may engage in consensual sexual activity with peers who are less than 4 years older without criminal liability. In contrast, California's laws are among the strictest. The age of consent is 18, and there are no close-in-age exemptions. This means that any sexual activity between an adult and someone under 18 is considered illegal, regardless of age difference or perceived consent. Offenders may face severe penalties, including felony charges and registration as a sex offender. On the other hand, states like Iowa and Indiana have set the age of consent at 16, but also include exceptions for individuals who are close in age. These laws reflect an understanding of the reality of teenage relationships, while still maintaining protections against exploitation. It's also important to recognize that age of consent laws can be influenced by other factors. For example, relationships between individuals in positions of authority, such as teachers, coaches, or religious leaders. And minors may be subject to stricter regulations, even if the minor has reached the age of consent. These laws are designed to prevent abuses of power and protect vulnerable young people from coercion or manipulation. Additionally, age of consent laws intersect with other legal concepts, such as child pornography statutes. Possession, distribution, or creation of sexually explicit images involving minors is strictly prohibited under federal law, regardless of the age of consent in a particular state. This means that even if two teenagers engage in consensual sexual activity, sharing explicit photos or videos can still result in serious criminal charges. Federal law also plays a role in certain circumstances. For instance, the federal age of consent is 18, and transporting a minor across state lines for sexual purposes is a federal offense, regardless of the age of consent in the states involved. This is intended to prevent forum shopping, where individuals might attempt to circumvent stricter laws by traveling to a state with a lower age of consent. Understanding the age of consent is especially important for young people, parents, educators, and anyone who works with youth. Ignorance of the law is not a valid defense, and violations can have lifelong consequences. Registration as a sex offender, for example, can restrict housing options, employment opportunities, and social relationships, creating significant barriers for those convicted. It's worth noting that age of consent laws are not static. They can be subject to change through legislative action, often in response to evolving social attitudes, new research, or high-profile cases. Advocacy groups may push for stricter laws to protect minors, while others argue for more lenient or nuanced approaches that reflect the realities of teenage relationships. As you consider these laws, it's important to remember their underlying purpose: to protect young people from exploitation, abuse, and harm. While they may sometimes seem restrictive or confusing, the ultimate goal is to promote safety, respect, and healthy relationships. For anyone seeking clarification on the age of consent in their state, reliable resources include official government websites, legal aid organizations, and advocacy groups focused on youth rights and protection. When in doubt, it is always best to err on the side of caution and consult a legal professional. In summary, the age of consent in the United States is a complex and nuanced topic, shaped by state and federal laws, social attitudes, and the need to protect minors. While most states set the age at 16, 17, or 18, close-in age exemptions and other provisions create a patchwork of regulations that can be difficult to navigate. Understanding these laws is essential for anyone involved in relationships, parenting, education, or youth services, as the consequences for violating them are significant and far-reaching. Ultimately, age of consent laws are designed to safeguard the well-being of young people, ensuring that their choices are respected and their futures protected.